Moving to the courts now, the Senzo Meyiwa murder trial continued today. Nearly 9 years since the football star was killed at his girlfriend's family home in Vosloorus. The trial today continued hearing evidence about DNA samples taken from the scene of the crime. And it seems there's no conclusive evidence that DNA samples taken from the hat of one of the suspected intruders on that day, for example, match any of the accused. But now the court is set to move into a trial within a trial. This apparently deals with 2 alleged confessions taken from 2 of the accused. Let's unpack all of this now with legal analyst Elton Hart. Elton, thank you so much for joining us. Let's deal with the DNA samples. Yesterday and again today, we heard that there were some links to some of the accused. But what we understand is that for a match to be made conclusively, in other words, I would imagine to be able to use it in court properly, all samples in a swabbed region, for example, the hat, have to match, have to show the DNA of a suspect. Now, from what I could understand, that was not achieved, but there were some sort of partial matches. I wonder if you could explain this to us. Why is it not enough to say, yes, there's DNA evidence that the accused was present?
No, indeed, if we look at what the DNA analyst said, he explained the process, how it works, and they need to, I think they look at more or less 16 points of actually sort of half what one can say direct matches before they can conclusively say, okay, this is your DNA. Because, and we must now also know South Africa is sort of half, and DNA is something unique, but also because of South Africa, the nature of South Africa, you might have people that has some traces of DNA that is similar. Not exactly, but there's similar traces. So for them to only have like 6 points of 7 points is not enough to say conclusively, we can without a doubt say that this is the DNA that belonged to that person. And obviously, the state did not help itself by presenting this evidence, because now it means that all 5 accused, based on the DNA, there's not conclusive proof that they were in the house. And then it speaks to now the evidence that was given by Tumelo Madlala, Zandi Kumalo, and Mtokozizi Twala that said one of the intruders were the head. So now it's sort of half. The accused stand one side and there's intruders. So it might be now, or the inference might be drawn there to say there was other intruders and not the 5 accused persons, or maybe that story that or the testimony that they gave that there was an intruder with a head is not even true. So it will now come down to the judge needing to make credibility findings against who he believes was a credible witness and not. But obviously the DNA evidence is undisputed as it stands now.
Okay, so am I right in what you in understanding what you said is that DNA is not like a fingerprint? It isn't absolutely unique to every person?
It's like DNA, it's also unique, but also for it to be conclusive, you need to have that 16 touching points, if one can say so, the reference, because of how South Africa is, our population. There was a lot of, like, what we can say cross-cultural relationships. So there is similar trends that you'll find, maybe if we refer to white, colored, black, Indian people that has similar trends in their DNA or similar looks in their DNA, but not exactly. But so that is where, with a fingerprint, that is totally different because your fingerprint is unique to you. So the DNA, it differs a little, but there is something closer to the fingerprint, but it has also the similarities, but also the differences. And that's even how you have with identical twins.
Okay. So then why would the state lead evidence that doesn't actually work in favor of their case?
Remember, Sally, one needs to also know, and the state prosecutor's job is not to prosecute and find everybody that stands in the accused dock guilty. If the state is in possession that actually exonerate accused persons, they are obliged by law to actually make that evidence available to the court so that the court can properly administer justice. So if the state, but we could see that the state also tried to say, okay, but is that the only conclusive inference that can be drawn? And the DNA analyst was clear to say that they cannot say that these people conclusively. So sometimes you can see, but the state must provide that evidence to court so that the court knows there's this evidence, they took it from that cap, and it doesn't conclusively state that these people were in that in that house on that fateful night when Senzo Meyiwa was killed. So there's case law to that. He must provide it.
I mean, how much of a blow is this to the prosecutors? Is it enough potentially for these men to walk free?
No, indeed, it would now speak to them not. There's not beyond reasonable doubt that they can be placed on the crime scene. Hence, I saw that they're going to now call a second cell phone analyst to come and testify, so that they maybe try and use what they call cell phone triangulation to actually maybe see at the date and time when they said Senzo Meyiwa was shot and killed. Maybe if they can use cell phone triangulation and put them in a triangle close to the Kumalo's house in Vosloorus. But if that evidence also come back and it can't place, and maybe it shows that Mtanzi was at that stage actually in KwaZulu-Natal, then it's a big blow for the state's case, because then we won't even go into the accused getting into the box and even favor us with their version of what they said happened, or maybe to give a defense. Then the court will have to look at Section 174 to discharge them, because the evidence is not enough.
Okay. We also heard from Hendrik Mulder this afternoon, who's from Sibanye Stillwater, talking about accused number 2, Mr. Mtanzi. Now, he applied for leave between the 27th and the 31st of October 2014. The 26th of October, which is the day Senzo Meyiwa died, was a Sunday, so he didn't apply for leave on that day. I know that that's going to continue, I think, tomorrow morning, so I'm not going to jump into that with you right now. I do want to ask you, though, about this trial within a trial, that there's talk of 2 confessions that now have to be looked at. Tell us about a trial within a trial. Tell us what is known about these supposed confessions from 2 of the accused.
Now, obviously, a trial within a trial is obviously when you have pointing out ID parades, confessions, or evidence that was unlawfully obtained from whatever source. Then they will go into what they call a trial within a trial to actually look at, is this evidence admissible? So they will deal with the admissibility of the evidence to see if it's admissible and if it's even relevant to the issues in dispute within this trial. So, and I know in 2020 when this accused was apprehended and then subsequently arrested, they said at some stage they were tortured into actually making certain confessions, because the police tortured them to actually make confessions. And at that point in time, they did not have legal representation. They were in person. So that, for me, it speaks to a trial within a trial. Obviously, it will unravel as to what is it that they fully said or is going to say what was done to them in order to make certain confessions. And then the court has to make a ruling to say if these confessions will be allowed as evidence that can be led by the state or not.
All right, so that could in part begin tomorrow, those discussions, but we are due to hear more from this Hendrik Mulder, who's on the stand today from Sibanye, which is one of the former employer of the accused number 2. Thank you so much for just giving us perspective on what has developed today at the Senzo Meyiwa murder trial. That's legal analyst Elton Hart. Now,